two neighboring nations, a massive consumer base, and a legal battle for total ownership over a single name. That name is Pisco, a specific type of regulated grape brandy. Production is dictated by the environment. The grapes are grown in these specific arid valleys tucked directly against the mountains. The spirit is then distilled using traditional copper stills, a process required to maintain its specific identity. To protect a product like this, countries use a Geographical Indication, or GI. It's a legal tool that confirms two things. The product comes from a specific territory, and its reputation is a direct result of that geography. The problem is that the historical region where this spirit was developed now sits on both sides of a modern political border, split between Peru and Chile. When modern borders divide a historical region, the legal system has to determine who has the right to use the traditional name in trade. That dispute reached the Delhi High Court, where both nations sought to control the name in India's expanding market. Peru's goal was total. They applied for absolute exclusive rights to the GI Pisco in the Indian registry. Their case was built on history. Peru argued the name belongs exclusively to them because its origins are tied to valleys and ports located within their modern borders. Chile disagreed, pointing to current market reality. Chilean Pisco is already an established product, exported and recognized all over the world. Chile provided a list of international free trade agreements to prove that dozens of other countries already recognize their right to the name. This left the Delhi High Court with a choice. If they granted exclusivity to one nation, they would effectively shut down the existing trade of the other. The court had to decide whether to protect the historical inventor or acknowledge the current state of global trade. To reach a decision, the court evaluated two paths: Peru's request for an absolute GI and a compromise known as a homonymous GI. Peru had the historical priority, but the absolute GI path ran into a major legal obstacle. Section 9A of India's GI Act forbids the registration of names that are likely to deceive or confuse the public. The court ruled that historical use and prior goodwill are irrelevant if the current consumer would be confused by the name. Because Chilean Pisco is a recognized product, an Indian buyer seeing a bottle simply labeled Pisco wouldn't know if they were buying the Peruvian or Chilean version. The court also addressed Section 9G, which deals with false representation, specifically whether using a name implies a product comes from a territory it doesn't. The judges found that while using the name Pisco isn't a false claim of origin, the lack of a clear prefix still triggered the rule against consumer confusion. The ruling makes it clear, IP registries are not historical tribunals. Their job is to protect the current market from deception. The court found its solution in Section 10 of the Act, which allows for homonymous GIs. This legal framework allows identically named products from different geographic regions to coexist. However, coexistence is conditional. It requires strict oversight to ensure the public isn't misled. Under Section 11.6, the IP registrar has the power to place mandatory conditions on an application. The court used that power to mandate a specific change. Peru must add the geographic prefix Peruvian to their GI. This prefix means Peru loses the status of a pure monopoly, but they successfully secure legal protection and market access in India. In order to stay in the international market, nations must often trade absolute exclusivity for a regulated, shared identity. We can map the court's ruling into a strategic framework for anyone registering a shared heritage name. First, does an identical product already exist globally under this name? If the answer is no, you can apply for an absolute GI. But if the name is shared, you move to the second node. Will a single registration cause market confusion? If confusion is likely, the law requires the application to be filed as a homonymous GI with a clear geographic identifier. The court's reasoning shows that geographic prefixes are not a penalty. They are the regulatory condition that allows trade to function in a saturated market. For IP lawyers, the lesson is to pivot. Stop trying to prove who used a name first in history and start proving how your product is distinct in the current market. For global exporters, factor geographic modifiers into your branding from day one to avoid years of expensive, unwinnable litigation. In the world of international IP law, sharing a name through a compromise is always better than losing the market entirely.